my principal witness, who is Senator Natasha Akpoti, that incident happened to, who reported to me. If she's not here to clarify, because she has every evidence, documentary evidence, oral evidence to testify, unless the senator allow her to come in for her to testify. That is the whole thing.
So if we can get a ruling on that.
So let me explain that to you. Hold on. Let me explain that to you.
Yes.
People in this matter are not here. Are not here. But he is the petitioner. Remember, he is a petitioner. It's his petition we are talking about. Not some phantom thing. It's his petition. And but the petitioner is speaking. Okay, so, and the petitioner, remember what he said, that he would not speak to his petition. If he will not speak to his petition because of the bias that is said is already on, may I finish, sir? If he will not speak to the petition for the reasons he gave, we won't even hear you, because there's something you're going to say, because he is the petitioner. You are here for the petitioner. You are not his witness. And if he will not speak to the petitioner, there's nothing we will hear from you, ma. So let me... No, you witness to what? Petitioner said he will not speak to his petition. We are witnessing to what? Ma'am, it's okay, we've heard you. We've heard you, ma'am.
You said you would hear me?
Once again, the chairman, distinguished senators of the Federal Republic of Nigeria, thank you for the opportunity. I want to say this. We received a petition that was served on my principal alongside...
Bubani,
yes.
Please, for record purposes, what do you mean by we?
Sorry?
We. Let's be clear.
Yes.
We. What do you mean by
the
we?
Senate President...
Please. Sorry, Chief Ubani. It's important. It's important.
It's
not his.
I'm not a petition. I'm a counsel. Yes. I'm speaking as a counsel. So I'm saying that, yes, my client received the petition and we went through the petition and the verifying affidavit. The truth of the matter is that when you have an affidavit, it is the evidence with which you prosecute your case. Unfortunately, the applicant or the petitioner has refused to adopt and possibly speak on the petition first before even the witness. Now, if you have given me the opportunity to look at the petition, we have a witness also that we have lined up in order to rebut whatever that has been already submitted to the distinguished Senate Republic of Nigeria. It's there already. We have the petition, we have the verifying affidavit. Verifying affidavit is the evidence. You don't talk about any other evidence because you enclose it. Whatever you have as an evidence is already in the verifying affidavit. So what we are saying is that if they are not going to adopt and you want us to rebut, we go ahead and then I put the witness that we have in order to rebut whatever has already been submitted before the distinguished Senate of the Federal Republic of Nigeria. We can rebut it. And then at the end of the day, if they want to go and probably want to ask questions, they can ask any question. They have a counsel here. My colleague, who is a professor of law, Dr. Abiola, can ask any of the witness of the respondent any questions. She has a right to do that. Just as I was also willing to ask question to the petitioner if he has gone ahead to adopt his petition, but he refused to adopt it, was alleging bias. Let me say this. He was mistaking the first incident where the suspended senator submitted her petition not in accordance with the rules of the Senate, and they told her that you have to comply. When she came back with that petition, she complied with the petition because she was no longer the person that signed it. She now presented it, and the Senate that day, if you recall what happened, accepted the petition and referred it immediately to the ethics committee, which is what the ethics committee is doing today, because he's mentioning the first instance where they said that it was dead on arrival because it was not in compliance with the rule. Now that the rule has been complied with and submitted properly, the Senate has referred it now to the Senate Committee on Ethics, Privileges, and Public Petition. They sat last Tuesday, invited them, they were not available, and he has explained why he was not available. Now effort was made in order to trace him, and he's here. So what I expect him to do is to adopt his petition. and then we now proceed from there. But if they have a tactics of delay or trying to misguide Nigerians and give an impression that there's no fair hearing, I think that the Senate committee should be able and wise enough to know that tactics and be able to do something concerning this petition. We are ready to defend it if they are ready to adopt it. That's what I want to say.
Chairman, distinguished colleagues, Mr. Zubeiru, you forwarded and signed a petition, true or false? So how does the other person come in? Are you not the author of this piece?
If you look at the body of the petition, it was clearly stated you will be here to testify and giving oral and evidence.
That is
and
after you
evidence.
are able to adopt the petition as yours. It is not for you to dictate the proceedings here.
No, sir.
Sorry, sir.
No,
Can
sir.
I speak as counsel? Since the counsel on the other side has spoken, sir.
Can my counsel speak, please?
Let me hear you.
And thanks for giving me that opportunity to speak. I've had the other counsel on this matter, and I've had the opportunity of also reading the rules of the committee. And I could see that the committee has a right to deal with do investigation and also to deal with issues of misconduct, which is what is before you. So we are not saying that by the jurisdiction of this committee, you don't have the power, to deal with this matter. However, what we are saying is that one of the things that my client had raised is the dead on arrival, which the SAN has also mentioned as one of the statements that had come from the chair of the committee at a point in time, which was raised on the 5th of March. Sir, please, which was raised on the 5th of March. The rules of the National Assembly is very critical, is important, but it must also be in sync with the Constitution of Nigeria, which dictates in the real sense what fair hearing will mean and what justice, will mean for Nigerians. And that is why we're saying that until when we read that the rule of this house and that constitution, that's when we can say that we have fair hearing and justice in this regard. In this regard, what the petitioner had said is that based on that press briefing, whether it was before Natasha was sent out of the National Assembly or not, gives an impression that the chairman of the committee has a particular understanding of this issue and could be said to be biased, on that issue with due respect, sir. And that is what my client is raising. Now, my client had raised one more point, that in the petition that he had put before you, sir, that the petition had said is going to bring the principal witness, Senator Natasha, as one of the witnesses to speak on this issue. And we are aware that the Senate had made a decision on where she can come and where she cannot come. And that is why we are saying we are ready to proceed. An oath has been taken. We have our witnesses ready. And the principal witness is Senator Natasha. So we don't also want people to go ahead and think that we deliberately came here, we have been called on serious. We have been called serious, some names here, that we deliberately came here to come and stalemate here. No, that is not our intention. Our intention is that if we are going to proceed, we think the chair of the committee should please step down from this conversation to allow for fairness and justice in accordance with the constitution of this country, because we can give evidence. Premium Times, March 5th, Arise, it was also recorded. We have several documentary evidence to show that at a point in time, the chair had said, dead or an arrival, she has no case to answer and other things, sir. Thank you very much.
Counsel, thank you very much. Just need to, so that we can... Mr. Ubani, this is for you. I don't know, I know all my colleagues have the papers. We can see that part of your defense is that there are cases in court. Am I correct?
Yes,
Just hold on. Am I correct?
Yes, you are correct.
Can you speak to, I just want, because I want us to be fair here. Can you speak to that and also speak to what I understand that, Madam Counsel, what you are saying, so that we are clear, is that you can't proceed because Senator Natasha is here. You want the proceedings, is not here. You want the proceedings adjourned to allow her come. Is that what you are saying? Okay. Okay. No. Am I correct? Okay. So, Mr. Ubani, can you speak to those two things? One, we have before us today your defense, which says there are cases in court. Two, they've said that they would like Senator Natasha to be here for this hearing. Can you speak to those two things?
On the issue of that the matter is sub judice, the truth of the matter is that the allegation of sexual harassment, the wife of distinguished Senator Godswill Akpabio has filed a suit, and I presented those two suits before the committee last Tuesday. There is a suit that had to deal.
Do you have it?
No, I submitted it, sir. I submitted it.
Plaintiff or petitioner, do you have what he defined?
Well, we don't have it, that's why it's in the paper.
Hold on, please, can you give them both?
Bring from.
So that
No, see, look at it. It's on defamation. It's on sexual harassment. Yes, as I said,
to allow you follow what?
yes, there are two.
Madam Professor, is to allow you follow his.
Where the wife of distinguished Senator Godswill Akpabio sued to enforce her fundamental human right regarding this allegation of sexual harassment that was made against her husband and the entire family. Then she also brought a writ of summons in which she's also asking for damages, all bordering on sexual allegation, not on cyberbullying. The defamation matter is one that suspended Senator Natasha brought. It's different from the allegation of sexual harassment in which the wife of Godswill Akpabio went to court in order to challenge and ask for damages that have been done to her husband and the entire family. So there are two suits. I presented it before the August committee last Tuesday. And so I'm sure my colleague has copies of the two suits. It's on sexual harassment. That is one with regards to issue that the matter is sub judice. Then the other issue you raise about Senator Natasha being present.
No, their prayer.
Okay, the prayer. The prayers.
Yeah, they pray that they would like to adopt that.
Yes.
And, testify. Am I correct? Yeah. And I said speak to that.
Yes. They have other witnesses. What I know about issue of witnesses is that you can take your first. So far, you have listed out the names of witnesses you have actually lined up for your case. You can start with the last person if the first person is not available, because it does happen that maybe your first witness is not available. You can start with that witness that is available in order to probably give life to whatever allegations you have made. So if the committee considers it worthy in the application that they are putting up now for an adjournment in order to allow distinguished Senator Natasha to come and give evidence, the committee has the right to reach that decision. But for me, if they have other witnesses, they can start by adopting and then go on with witnesses that they have today so that we can make some level of progress. That's my advice.
Please turn off your mic.
Thank you, sir.
Mr. Suberu, for coming, please. Let me, I want to address something. Okay. Please. For coming before us. Learned Council, I've heard you. You said because I made a statement in Arise, if I'm correct, therefore I should recluse myself because that shows bias. But let me tell you, and I use the word dead on arrival. That case that came before us, the first petition that came, is not this petition. That petition was signed by distinguished Senator Natasha Akpoti. Contrary to our rules, you cannot sign your own petition. 2, a petition that came before us did not even have an address. Contrary to our rules, that petition shouldn't have been entertained. Because you are a learned council, submit a case, submit your own petition to court, and don't sign it. They will throw it out. Whether you use the word dead on arrival or not, they will throw it out. We are lawyers here, so we understand that. In any case, from the position that I can see you are taking, it means the whole Senate is biased. Because the whole Senate witnessed what happened on the floor. They witnessed it. And so, I don't know what other committee you're going to now constitute that is not aware of what has been going on. 2, learned respondent has just told us, and I'm sure you have the case file and index number in front of you, that this matter is before a law court. and I will address that. And we'll address that by our rule book, which says Order 47. And I will read on record. Senate should not receive or deliberate on any matter to which actions are pending in any court of law. Senate should not receive or deliberate on any matter to which actions are pending in any court of law. This is our rule book, Senate Standing Orders 2023 as amended. And I'm glad you said you have had the opportunity to read this rule book. Therefore, based on two things. One, the petitioner said he would not speak to his petition because the Senate is biased, or I'm biased, or the committee is biased. Two, the respondent has just told us, and the papers are before you, that this case is before a competent court of law. Therefore, this committee will allow a court of law that will not be biased to handle this matter. Therefore, this matter is closed here at the Senate and is adjourned.
And God, just subscribe, like, comment, and share. Thank you, and God bless you.